PVL3701, Property Law, Study Unit 11, Real Security Rights. Part 1, Conventional Mortgages. Number 1, Introduction. In this study unit, we discuss real security rights. Real security rights form the second group of limited real rights, the first being servitudes and conditions of title. We discuss the following real security rights: pledge, mortgage, security by means of claims, tacit hypothecs, liens, and judicial pledge. Number 1.1. Real security rights and personal security. Real security rights are limited real rights over another person's thing, that is, jura in re aliena. Real security rights secure performance by a security grantor that the debtor will perform his or her obligations towards the security holder or the creditor. Two basic forms of credit security can be distinguished: personal security and real security. Personal security occurs where a person, the surety, binds himself or herself personally to the creditor for the performance of the debtor's obligation. Take note that the security receiver in the case of personal security, that is, suretyship, obtains only a personal right, that is, a creditor's right against the surety, while in the case of real security, he or she obtains a limited real right to the thing of the security grantor. The law of property is, however, concerned only with real security rights, while the principles of surety are dealt with in the law of obligations, specifically in the law of contract. And then you can just study diagram 17 on your own time concerning real and personal security. Number 1.2, Real Security Rights. Number 1.2.1, Limited Real Rights. In the case of real security rights, the person accepting security obtains a limited real right over a thing as security for the fulfillment of an obligation, that is, the principal debt. If the principal debtor does not fulfill the obligation, the creditor can use the security object, the thing, to satisfy the debt. Number 1.2.2, Conventional and Tacit Real Security Rights. Real security rights, that is, limited real rights, are divided into conventional or express security rights, which are based on agreement between the creditor and the debtor, and tacit mortgages arising by operation of law. Tacit mortgages, unlike conventional mortgages, are not created by agreement and registration, but by operation of law, independently of the creditor's and the debtor's wills. For this reason, tacit mortgages are also sometimes called legal mortgages, that is, mortgages ex lege. Tacit mortgages are discussed below. Number 1.2.3, Preferential Claim. Real security rights are aimed at strengthening the creditor's position, especially in the case of a concurrence of creditors, that is, concursus creditorum, that is, the debtor's insolvency. Every debtor is contractually obliged to pay his or her debt, and his or her estate, in general, is liable for proper performance. However, where a debtor has a number of creditors and where his or her liabilities exceed his or her assets, the liability of his or her assets is a poor consolation. Moreover, a debtor may alienate all his or her assets, leaving the creditors without recourse. Where several creditors have claims to the same estate on insolvency, the principle of equality of creditors, that is, paritas creditorum, applies. According to this principle, all creditors are on equal footing as holders of claims, that is, personal rights or creditors' rights, and none is entitled to preference. To avoid this unsatisfactory position, a creditor may secure his or her claim for payment by means of a real security right, which will give him or her a preferential claim to the proceeds of the object of security. The security holder can have the object of security sold in execution. Only when his or her claims has been satisfied can the unsecured creditors, lay claim to the free residue. The real security right also entitles the secured creditor to prevent the debtor from disposing of the security object, since the creditor is physically in control of the object of security in the case of a pledge, for example, and in the case of a mortgage. Registration against the title deed has been effected. Number 1.2.4. Legal acts involved in creation of real security rights. It is important to distinguish between the different parties as well as the different agreements that are relevant in conventional real security rights. The parties are usually the security holders, that is, the creditor or credit grantor, and the security grantor, that is, the principal debtor or a third party. The person who furnishes security is usually the debtor, but this need not be so, since it is possible to provide security for another person's debt. The person in whose favor the security is provided is, however, always the creditor. The owner of a thing, or his or her representative, is the only person who is entitled to burden a thing with a real security right. In a security transaction, the following legal facts can be distinguished. Number 1. The loan contract, or other credit facility, in terms of which the creditor lends a sum of money to the debtor. The debt created here is the principal debt. Number 2. The security contract. This can exist independently or be incorporated in the same document as the loan contract, in terms of which the security grantor undertakes to provide security for the debt created in terms of the loan agreement. The security contract determines the nature of the security, in other words, if a pledge or a mortgage is constituted. And then number 3, constitution, vesting of the limited real right. Once the above contracts have been concluded, the real security right must still be constituted or vested. The act constituting the real security right, for example, in a pledge, is the physical transfer delivery of the pledged object. To distinguish this delivery from delivery where ownership is transferred, the physical transfer goes hand in hand with a real agreement in terms of which the pledger has the intention to constitute a pledge over the pledged object, and the pledgee has the intention to accept it as a pledge. These different legal transactions are normally entered into simultaneously, but can be distinguished from one another, if not in time, in effect. And then you can study diagram 18 regarding the legal acts involved in creation of real security right. And then number 1.2.5, accessory nature. A real security right, conventional and tacit, are accessory in nature. This means that the security rights cannot exist if there is no principal debt. When the principal debt is discharged, the security right is extinguished by operation of law. This principle is enunciated as follows in Kilburn versus Estate Kilburn in 1931. It is true that you can secure any obligation, whether it be present or future, whether it be actually claimable or contingent. The security may be suspended until the obligation arises, but there must always be some obligation, even if it be only a natural one to which the security obligation is accessory. If there is no obligation whatever, there can be no hypothecation giving rise to a substantive claim. The principal debt may arise from a contract or a delict, or from other causes such as unauthorized management of another's affairs or enrichment. It may also arise from a natural obligation or an obligation which is subject to a condition or a time clause. The Deeds Registries Act number 47 of 1937, that is section 51, even makes it possible to secure a future debt by means of a covering bond. Okay, number 1.2.6, security object. Any movable or immovable thing that is part of the commercial world in commercio can be the object of a real security right. It may take the form of a single thing like a car or a horse, or a composite thing, such as an estate or a herd of livestock. It can also be an incorporeal thing, like a personal right or a servitude. Real security rights are indivisible. Unless there is an agreement to the contrary, they secure the entire claim, the principal debt. In other words, the whole thing remains burdened until the whole debt has been paid. Number 1.2.7. Different meanings of mortgage. The word mortgage is used in a variety of meanings. In a generic sense, it refers to a real security right, including pledge, mortgage, and hypothec. Note too that there is a difference in the functioning or effect of a right of mortgage and a mortgage bond, that is, a mortgage deed. The mortgage bond or deed is the document embodying the terms and conditions of the mortgage, that is, the real security right. In this course, the emphasis falls on the functioning and effect of a of a right of mortgage as a limited real right. You should be able to define and distinguish the different types of mortgages. Okay, and now for part 2, the pledge, mortgage, or security by means of claims. And then we go on to page 210, introduction. In this section, pledge, mortgage, and security by means of claims are discussed. Okay, and then number 2, pledge. Number 2.1, definition. A pledge can be defined as a limited real right over a pledge's thing, delivered to the pledgee as security for repayment of the principal debt, which the pledger or a third party owes to the pledgee. Number 2.2, constitution or vesting. And then there's an example based on the facts in Vasco Dry Cleaners versus Twycross in 1979. In 1979, Z sold his dry cleaning business, Vasco Dry Cleaners, to X. It was a term of the contract of sale that, in respect of the dry cleaning machinery included in the sale, the passing of ownership would be suspended until the purchase price has been paid in full. At the end of June 1972, the balance still due to Z was 4,650 rand. X was in financial difficulties, and in order to avoid repossession of the machinery by Z, he sought and obtained financial assistance from Twycross, his brother-in-law. X and Twycross accordingly entered into a written agreement on the 28th of June 1972, in terms of which Twycross was to pay the balance still due to Z. It was agreed that on such payment to Z, ownership of the machinery would pass to Twycross, who agreed to sell the machinery to X for a purchase price of 4,700 rand, payable on or before the 30th of June 1973. It was further agreed between X and Twycross that the ownership of the machinery would not pass to X until the purchase price had been paid in full to Twycross. They agreed that if the purchase price was not paid, Twycross would be entitled to obtain the return and repossession of the machinery. In November 1972, X sold the business, including the machinery, to a new owner. In the deed of sale, X warranted that it was the owner of the machinery. The new owner of Vasco Dry Cleaners was not aware of the contract between Twycross and X. X failed to pay Twycross the sum of 4,700 rand. Twycross wishes to claim the machinery from the new owner. The following are required to constitute a pledge. Number 1, a principal debt. Number 2, a pledge agreement or a security agreement. And thirdly, delivery. The accessory nature of pledge requires the existence of a principal debt. The pledge agreement or security agreement is an agreement creating an obligation. The pledger undertakes to give the thing in pledge. The pledgee does not acquire a real right to the thing until delivery has taken place. He or she merely acquires a personal right or a creditor's right or claim by virtue of the pledge agreement to compel the pledger to deliver the thing. Since the transfer of control is required for the vesting of a pledge, it is usually accepted that only movable corporeal things can be given in pledge. And then you can just study the vesting of pledge in diagram 19 on your own time. The requirement of transfer of control has given rise to certain problems in practice, and several methods have been devised to circumvent this requirement. Certain authors advocate a non-possessory pledge, since transfer of control has an inhibiting effect on the credit grantor's business. The courts eliminated most of the devices for circumventing this requirement and followed a conservative approach, requiring the transfer of control by means of actual or constructive, that is, fictitious delivery. Constitutum possessorium as a constructive, fictitious form of delivery for the constitution of a pledge is, however, unacceptable because it provides ample opportunity for fraud. Constitutum possessorium is a form of constructive fictitious delivery where the transferor or the pledger remains in control of the thing and exercises control on the transferee's pledgee's behalf. Since the transfer of control is a requirement for the constitution of a pledge, it is not possible for more than one pledge to exist at the same time over the same thing. And then there's just an activity. And then we go on to number 2.3. Clauses in pledge agreement, also relevant to clauses in mortgage agreements. Number 2.3.1. Clause for summary execution. Execution without court order, that is, parate executi. Okay, sorry. And then there's an example based on the facts in Osri versus Hirsch and Lobster and Co., 1922. S hands ostrich feathers to Z to sell on his behalf. Z is unable to sell all the feathers. Z advances a large sum of money to S and agrees that he will try to sell the feathers, if necessary, at a public auction. The feathers will serve as a pledge object to secure repayment of the money advanced to S. Z sells the feathers at a public auction and buys them at a very low price. S argues that this sale is invalid since it was executed in terms of an invalid summary execution clause. Okay, the pledger and pledgee may agree that, in case of default payment, the pledgee may sell the thing without an execution order from the court. Such a clause is valid, and should such a sale take place, the pledger may seek the protection of the court if he or she was prejudiced by the sale. After the debt has been satisfied, the pledger is entitled to the balance of the proceeds, and he or she may claim it by means of his or her action upon pledgee. Then we move on to number 2.3.2. Clause that pledgee may keep thing if pledger fails to pay. A pactum commissorium. And then there's an example. B. One of S's farm workers wants to borrow 2,000 rand from S. He offers an antique pocket watch which he inherited from his grandfather as security. S accepts the watch and B signs a document in which he agrees that S may keep the watch if B does not repay the full amount within 6 months. The clause that the pledgee may keep the thing if a pledger fails to pay in his or her debt is invalid. Okay. Number 2.3.3. Clause that pledgee may buy thing at specific price. And then there's an example based on the facts in Mapinduka versus Ashington, 1919. S buys 152 bags of maize from C, the cooperative, on credit. As security for repayment of the debt, he leaves 6 oxen, a cow, and a horse with C as a pledge. The parties agree in writing that C may keep the pledged animals if S does not repay the debt on the due date. S fails to pay, and C regards the animals as his property in terms of the written agreement between himself and S. 2 years later, S tenders 8,000 rand as payment for the outstanding debt. He also claims his animals back, or 12,000 rand as damages in lieu of the animals. Okay, although Foot regards a stipulation that the pledgee may buy the thing at a specific price as valid, its application was restricted in Mapinduka versus Ashington 1919 to the case where the agreement was made after the debt had become due or where the agreement preceded the due date, only if the pledger at the time of non-payment was prepared to part with ownership of the thing at the agreed price. The pledger and pledgee may also agree that the pledgee may keep the thing at a fair price or at a price determined by a third party, if the pledger and pledgee cannot reach consensus. Number 2.3.4, a clause that debts may not be redeemed. Such a clause preventing the pledger from paying his or her debt and having the pledged article restored to him or her is invalid. Number 2.3.5, Pactum anticresis. Normally, the pledgee may not use the fruits of the thing given in pledge. However, the parties may agree that the pledgee may do so, instead of claiming interest on the amount owing by the pledger. And then there's an activity. Then we move on to number 2.4, rights and duties of parties. Number 2.4.1, pledgee. The pledgee acquires a limited real right to the pledged article. This right enables him or her to keep the thing in his or her control until the pledger has paid the principal debt. In the case of involuntary loss of control, the pledgee can claim it by means of the real actio quasi serviana from whoever is in control of the thing, even a bona fide purchaser. As a lawful holder, the pledgee may also use the spoliation remedy to recover control of the pledged thing from a person who has unlawfully removed control from the pledgee. If the pledgee voluntarily loses control, the principle that movables cannot be followed up in the hands of a bona fide third parties in the case of a hypothec applies. In this instance, the pledgee cannot claim the thing, and also loses his or her limited real right as pledgee. If the pledger is unable to pay the principal debt, the pledgee may obtain judgment against him or her and have the thing sold in execution by the sheriff or messenger of the court. The pledgee can satisfy the debt from the proceeds and must pay the surplus to the pledger. If the pledger is declared insolvent, the pledgee enjoys preference by virtue of his or her pledge, and his or her debt is satisfied from the proceeds of the sale of the pledged thing. The pledge applies not only to the thing itself, but also to the fruits and the offspring. Therefore, if X has taken a cow in pledge and the cow gives birth, the calf will also be subject to this pledge. The pledge may recover any necessary expenses he or she has incurred in the maintenance of the thing, by means of the actio pignoratitia contraria. Okay. The pledgee is obliged to take care of the thing as a reasonable man or person would do. He or she is liable to the pledger for any damage to the thing caused by his or her fault, but he or she is not liable for damage caused by chance. For example, damage caused by lightning. When the debt is paid, the pledgee is obliged to return the thing to the pledger. Number 2.4.2, pledger. If the pledgee should use the pledged article in a way that is contrary to the pledge agreement, the pledger may require security of him or her that he or she will refrain from doing so. When the pledger has paid his or her debt, the pledge is extinguished and the pledger can reclaim the pledged article from the pledgee by means of a personal action. The actio pignoratitia directa, or from whoever is in control of it with the re vindicatio, a real action. When the pledge has been extinguished, the pledgor is obliged to refund the pledgee for any necessary expenses he or she may have incurred with regard to the maintenance of the thing. Number 2.5. Extinction of pledge. A pledge may be extinguished by number 1. Discharge of the debt. Number 2. Destruction of the pledged article. Number 3. Effluxion of time where the pledge was subject to a condition or time clause. Or number 4. The pledgee's renunciation of the pledge. Number 5. Novation of the principal debt. Number 6. Merger where the pledgee becomes the owner of the thing. Number 7. Prescription. Number 8. Voluntary loss of control. Number 9. Court order. Or number 10. Sale in execution. Okay, and now we go on to number 3. Mortgage. Number 3.1. Definition. A mortgage can be defined as a limited real right over a thing belonging to the mortgager in order to secure repayment of a debt owed by the mortgager or a third person to the mortgagee. Number 3.2. Kinds of mortgages. We referred to the different meanings of the term mortgage above and also to the fact that mortgages in the generic meaning as hypotheques can be divided into two groups, namely, number 1, conventional or express mortgages, that is, mortgages by means of agreement, or number 2, tacit mortgages, that is, mortgages created by operation of law. In its narrow sense, mortgage refers to the situation where the creditor is not in control of the object of security. An express mortgage is established by a mortgage agreement and registration. Because of the accessory nature of real security rights, there must be a principal debt. Both movable and immovable things may be burdened by such a mortgage. Number 3.3. Kinds of conventional or express mortgages. Number 3.3.1. Notarial bond. Number 3.3.1.1. Introduction. A notarial bond is a bond registered over the movable property of the mortgager. The legal position pertaining to notarial bonds has an interesting history. Prior to the enactment of the Security by Means of Movable Property Act number 57 of 1993, the legal position pertaining to notarial bonds in Natal was different than in the other provinces. The legal historical development of notarial bonds is not fully discussed here. See the module on notarial practice for a comprehensive discussion of notarial bonds. For purposes of this module, you must have knowledge of the following aspects pertaining to notarial bonds: the definition of, the difference between, and the vesting and legal operation of general notarial bonds and special notarial bonds. Number 3.3.1.2. Definition. A distinction is drawn between general notarial bonds and special notarial bonds. A general notarial bond burdens all the movable things of the mortgager in general, whereas a special notarial bond burdens specified movable things. A general notarial bond burdens all the movable property, for example, all the farm implements, tractors, and livestock of a mortgager or debtor. This notarial bond creates no limited real rights but has certain advantages for the mortgagee, the creditor, in the case of the mortgage's or debtor's insolvency. The legal position pertaining to general notarial bonds is governed by the common law. In terms of the security by means of movable property, a special notarial bond is a bond attested by a notary and registered over certain specifically described corporal movable property. For example, the green John Deere tractor of a mortgager or the debtor in favor of a mortgagee or creditor as security for the repayment of the principal debt. A special notarial bond can be registered over incorporeal movable property. After the registration of the special notarial bond, it grants a limited real right, that is, a real security right over the specified movable property to the mortgagee, the creditor, with other movables being delivered to the mortgagee or the creditor. This form of security is beneficial to the mortgager, the debtor, since he can, unlike in the case of a pledge, still use the movables while they serve as security. And then you can just study diagram 20 about notarial bonds as security objects. Number 3.3.1.3 Vesting. Both general notarial bonds and special notarial bonds must be attested by a notary and registered in the deeds office. A. General notarial bond. A general notarial bond does not create a real right of security in favor of the bondholder. If a valid and enforceable perfection clause is included in the bond, however, the bondholder can acquire a limited real right of pledge on attachment of the bonded articles. The mortgagee can get control in terms of the perfecting clause when, number 1, the mortgager agrees to it, or number 2, in terms of a court order for specific performance and execution, if he or she refuses. Perfecting the bond refers to the method in terms whereof the notarial bond acquires real operation. Okay, and B. Special notarial bond. The Security by Means of Movable Property Act No. 57 of 1993 determines that a real security right vests on registration of the special notarial bond. In terms of Section 1, subsection 1 of the Act, such movables, if specified and described in a way that renders them readily recognizable, shall be deemed to have been pledged as effectually as if they had been pledged and delivered. In IKEA Trading, UN and Design, AG versus Bow Bank Limited in 2005, sorry for my pronunciation, the debtor registered a special notarial bond over certain of his movable property in favor of BOE Bank or Bow Bank. The movable property was listed in a schedule attached to the bond, but not described and specified in the bond itself. A year later, the debtor was declared insolvent, and IKEA Trading and Design AG, a creditor of the debtor, then contested the validity of the special notarial bond on the grounds that it was impossible to identify the specific movable assets from the bond itself, and that the movable assets were therefore not readily recognizable, as required by Section 1, subsection 1 of the Security by Means of Movable Property Act No. 57 of 1993, and that external evidence had to be used to identify the specific movable assets. The court had to determine whether a special notarial bond is valid when the movable property over which the bond is registered is only described and specified in an attachment to the bond. The Supreme Court of Appeal refers to Section 1, subsection 1 of the Security by Means of Movable Property Act No. 57 of 1993, in terms of which movable property must be described in the notarial bond in a manner that deems it readily recognizable. The test to determine whether the movable property is readily recognizable is whether a third party can recognize the movable property from the description in the notarial bond without the use of extrinsic evidence. According to the court, a notarial bond must, as far as possible, have the same characteristics as a pledge. Physical control of a pledged thing is required. Delivery by way of constitutum possessorium is not possible, since physical control is required for a valid pledge, and serves as publication to third parties. The notarial bond, as in the case of physical control for a pledge, serves as publication of the existence of a real right to third parties. The notarial bond must therefore contain a complete description of the object of the real security right. Consequently, the court held that the notarial bond registered in favor of BOE Bank is invalid, as the movable property is not readily recognizable from the notarial bond. Number 3.3.1.4 Legal Operation. A. General Notarial Bond. The Security by Means of Movable Property Act No. 57 of 1993 does not affect this type of bond. A distinction is drawn between the position before and after perfection by means of attachment. Number 1. Before perfection. This bond does not enjoy preference over a special notarial bond. Priority is determined with reference to the date of registration. This bond does not create a real right of security in favor of the bondholder. The movables subject to this bond can therefore be attached in the hands of the mortgagor and are also subject to the landlord's tacit hypothec, which would enjoy preference. In terms of Section 102 of the Insolvency Act No. 24 of 1936, the general notarial bondholder enjoys preference in respect of the free residue over the concurrent creditors of the debtor. This view was confirmed in Cooper N.O. versus De Meester 1992, sorry. And then number 2, after perfection. If a valid and enforceable perfection clause is included in the bondholder can acquire a limited real right of pledge on attachment of the bonded articles in terms of a court order. The bondholder or creditor will be in the same position as a pledgee and thus have a secured claim or limited real right. Okay, and B, special notarial bond. The Security by Means of Movable Property Act No. 57 of 1993 clearly states a fictitious non-possessory pledge on registration of the bond in the bondholder's favor. It is therefore unnecessary to perfect the security, since such perfection will afford the bondholder no stronger protection than the Act provides for. The Act creates a real security right in the form of a pledge, and this notarial bondholder is therefore a secured creditor who can realize his or her claim as such in terms of Section 83 of the Insolvency Act No. 24 of 1936. Then you can just study diagram 21 on your own time, and then there's also an activity. And then we move on to number 3.3.2, special mortgage over immovable things. And then there's an example. X and Y owe L, the land bank, 100,000 Rand. L requires security for payment of the debt. X and Y grant a mortgage over their farm to the land bank. They agree in the mortgage deed that the land bank, without the intervention of the court, may sell the farm if X and Y do not pay their debt, or may keep the farm and have it registered in its name if X and Y do not pay their debt. A special mortgage can be established only with regards to a particular immovable thing and cannot be established over immovables in general. It is deeds registry practice to endorse the existence of the bond against the title deed of the land. In Standard Bank van SA versus Breitenbach 1977, however, this endorsement was not considered to be a requirement for registration of the bond, since a bond is deemed to have been registered in terms of the Deeds Registries Act No. 47 of 1937, when the Registrar of Deeds has signed the bond. And then there's another activity. And then number 3.3.3, a custing brief. A custing brief can be defined as a special mortgage over an immovable thing to secure a principal debt that has been incurred in respect of the purchase of that thing, where the deed of hypothecation is registered simultaneously with the deed of transfer of the particular thing. An example of this type of bond is when S buys a farm from Z but is only able to pay part of the purchase price. S can then register a custing brief in favor of Z over the farm as security for the outstanding part of the purchase price that he owes Z. Okay, and then number 3.3.4, covering bond. A covering bond can be defined as a special mortgage over an immovable thing securing a future debt. It must be expressly declared to secure a future debt, and a maximum amount must be stipulated. The preference conferred by this bond is determined by the date of its registration, and not by the date on which the debt is incurred. The object of the security will determine the type of bond. And then number 3.3.5, participation bond. It is a well-known commercial practice for investors to make money available to investment companies, who in turn lend out the collective amount they obtain in this way against the security of a mortgage bond over immovables. The Collective Investment Schemes Control Act number 45 of 2002 allows for the fragmentation of mortgage bonds without the consent of the mortgager in such cases. The bond is registered in the name of a nominee company as the representative of the participants. The debt owed by the mortgager is deemed to be a debt owed to the individual participants to the extent of their participation in the scheme. Consequently, the limited real right created by the mortgage bond can be exercised by each participant to the extent of that person's participation in the scheme. Okay, and then there's just another activity. And then we move on to 3.4, Operation of Special Mortgage over Immovables. In establishing a special mortgage over immovable things, the mortgagee acquires a limited real right over mortgaged land. Although the mortgagee is not in control of the mortgaged land, the mortgager cannot establish any other real right over the mortgaged land without the mortgagee's consent. It is not necessary, however, for the mortgagee to consent to the registration of a long lease contract which creates a limited real right over the mortgaged land. Nor is it necessary for him or her to consent to the registration of an additional mortgage over the mortgaged land. Since the mortgager retains control of the mortgaged land, it is possible for him or her to constitute more than one mortgage over it, and the first registered mortgagee enjoys preference over the subsequent mortgagees. That is, qui prior est tempore potior est jure. The mortgagee's right is not over the mortgaged land only, but also over any attachments to it. As soon as the mortgager discharges his or her debt to the mortgagee, the mortgage is extinguished. The mortgager is entitled to pay his or her debt and discharge the mortgage before the date of payment, provided that he or she also pays the interest in advance up to the date of payment. If, however, the mortgager fails to pay the whole debt on the due date, the mortgagee can obtain judgment against him and have the mortgaged thing declared executable and sold in execution by the sheriff. We refer to this process as foreclosure. Okay. The action which a mortgage may take on the ground of a mortgage is called a claim for provisional sentence. It is an urgent remedy. In this proceeding, the mortgager can deny only his or her signature on the bond or that he or she authorized signing of the bond on his or her behalf. The mortgager must first comply with the judgment before he or she can raise any defenses on the merits. The mortgagee furnishes security to restore, in case of any of the mortgagee's defenses are subsequently upheld at the hearing. Keep in mind that Section 26 of the Constitution of 1996 has an influence of the eviction of the mortgager. The mortgager and mortgagee usually insert clauses in the bond with regard to the repayment of the debt and interest. They would stipulate under which circumstances the bond may be foreclosed. A summary execution clause as well as a pactum commissorium is invalid in the case of a mortgage. The mortgage does not make the mortgaged thing in any way immune from attachment by the sheriff or the messenger of the court by virtue of another creditor's having obtained judgment against the mortgager. However, because of the priority principle, it does give him or her the right to place a reserve price on the mortgaged thing. And if the mortgaged thing is sold in execution, the mortgagee has a preference in respect of the proceeds for the repayment of his or her claim, which is secured by the mortgage. The preferential rights conferred by the various mortgages in the case of insolvency are regulated by sections 86, 87, and 88 of the Insolvency Act number 24 of 1936. Okay, and then number 3.5, extinction of mortgage. Mortgage is extinguished by number 1, extinction of the principal debt, for example, by payment, set off, etc. Sorry. And number 2, destruction of the mortgaged thing. Number 3, extinction of the mortgagee's title in respect of the mortgaged thing. For example, where the mortgagor, who is merely the usufructuary of the mortgaged thing, dies. Or number 4, express or tacit renunciation of the mortgage by the mortgagee. Number 5, a merger or confusio, where the mortgagee becomes the owner of the mortgaged thing. Number 6, a court order. Or number 7, delivery of the mortgaged thing to the purchaser in consequence of its sale in execution. Or number 8, prescription. Number 9, loss of control of a thing over which there was a lien. And then lastly, number 10, removal of the infecta et lata from the rented premises and transport to a new destination, by which the landlord's tacit hypothec is extinguished. And then there's a small activity. And then we move on to number 4, security by means of claims. Number 4.1, introduction. Security by means of claims can be granted in one of 3 ways. Firstly, a pledge of claims. Secondly, a fiduciary security cession. And lastly, a notarial bond of claims. Security by means of claims is therefore security by means of an incorporeal thing. Personal rights are assets in a person's estate. For example, X's personal right to his or her salary or his or her claim against an insurance company is an asset in his or her estate. Such assets can be sold and transferred by means of cession. Cession can be defined as an act of transfer in terms of which a creditor, a cedent, or transferor transfers his or her personal right, that is, the creditor's right or claim against his or her debtor to the cessionary, the transferee, in such a way that the cessionary steps into the shoes of the cedent as creditor. Okay, the transfer takes place by means of a transfer agreement. A personal right as an asset in a person's estate can, however, also be used to secure payment of a debt. It must be borne in mind that a personal right or creditor's right or claim as an incorporeal thing can sometimes be the object of a real right. The following example illustrates this. In the same way that I can deliver my car in pledge to my creditor to secure payment of the principal debt, I concede my personal right to payment of my salary against my employer to my creditor in pledge. The nature and effect of security by means of personal rights differ according to the type of security, as well as the difference in the nature of the object of the security, in one instance a corporeal thing and in the other an incorporeal thing. Okay, and then you can just study diagram number 22. Number 4.2, a pledge. In dealing with a pledge of claims, one should bear in mind that the principles that govern this legal institution are derived from the law of property, and specifically the principles pertaining to the law of pledge. Because of the difference in the nature of the object of the pledge in the case of a pledge of claim, which is incorporeal, it is self-evident that all the principles that apply to the pledge of a corporeal thing cannot apply mutatis mutandis to a pledge of claims. Although, in principle, these rules find application where the nature of the object permits, the basic rules must be adapted to make provision for the specific nature of the security object, that is, a claim. The following aspects of pledge deserve special attention in a pledge of claims: the nature and effect of a pledge, the constitution of a pledge, and the rights of the pledger and pledgee. In constituting a pledge of claims, the basic principles of the law of pledge, such as publicity, specificity, and the fact that a pledge is of an accessory nature, should be adhered to. In the case of a pledge of claims, the quasi-control of the thing is transferred to the pledgee, while the pledger retains ownership or dominion. The pledgee, therefore, only acquires a limited real right. Number 4.3, fiduciary security cessions. A fiduciary security cession takes place where a creditor X or the cedent transfers his or her personal rights against Y, his or her debtor, a third-party debtor to Z, his or her creditor or cessionary as security for payment of the principal debt. The right is transferred fully to the cessionary or creditor, but because it is not an outright transfer of the right, for example, in terms of sale and merely for security purposes, the effect of a full transfer of the right must be limited. This limitation takes place in terms of a fiduciary agreement. The agreement is called a fiduciary agreement because the trust which the cedent or principal debtor places in the cessionary or creditor underlies their relationship. The cedent or principal debtor agrees in the fiduciary agreement with the cessionary or creditor that the personal right is transferred for security purposes only. Consequently, the cessionary creditor may not enforce the personal right that has been ceded to him by claiming payment from the cedent or principal debtor's debtor, the third-party debtor, until the cedent or principal debtor's debt to the cessionary or creditor falls due and the cedent or principal debtor is unable to pay. Furthermore, the cessionary or creditor may not transfer the right ceded to him or her to other persons, and he or she must cede the personal right back to the ceded or principal debtor after the latter has paid his or her debt to the cessionary or creditor. The difference between the pledging of a creditor's rights, as discussed in paragraph 4.2 above, and fiduciary security cessions is that the creditor's rights in the first instance is merely pledged to the creditor as security for performance of the debtor and not ceded or transferred as in the case of fiduciary security cession. And then you can just study diagram 23 on your own time. And then number 4.4, notarial bonds of claims, incorporeal movable things. The Security by Means of Movable Property Act number 57 of 1993 makes provision in section 1, subsection 1, only for the registration of a notarial bond over specified corporeal movables. This Act excludes incorporeal movables from the operation of the Act, and it appears from Section 1, subsection 3, that it also excludes a special notarial bondholder of incorporeal things from enjoying the preference bestowed on special bondholders of movables registered before the commencement of the Act, since the section reads, subject to provisions of subsection 4, a notarial bond contemplated in subsection 1. This Act does not affect the position of the general notarial bondholder of incorporeal movable things. The effect of the wording in section 1, subsection 3 is such, however, that it excludes the special notarial bondholder of incorporeal things. Consequently, the general notarial bondholder of incorporeal movable things is in a stronger position than the special notarial bondholder of incorporeal things who, in terms of Cooper N.O. versus De Meester 1992, cannot rely on Section 102 of the Insolvency Act number 24 of 1936, and is, as a non-preferent creditor, liable to contribute to the costs in terms of Section 106 of the Act. See the discussion of notarial bonds in paragraph 3.3.1 above. And then there's just a small activity that you can study. Okay, and now for the last part, continuing on page 229, tacit mortgages or hypothecs. Number 1, Introduction. In this section, real security rights or limited real rights that arise by operation of the law are discussed. Tacit mortgages may be constituted over movable or immovable things. Unlike conventional mortgages, they are not created by agreement and delivery or registration, but by operation of law, independently of the creditor's and the debtor's will. For this reason, tacit mortgages are also sometimes called legal mortgages. They may be in respect of specific things, whether movable or immovable, or even in respect of the debtor's whole estate. You should be able to define each of these real security rights and distinguish them from one another. In the case of the tacit hypothek of the landlord or the lessor, you should know how the hypothek is constituted by attachment, and you should pay particular attention to the circumstances under which the movable things of third parties can be subject to the hypothek. Note that Section 2, subsection 1 of the Security by Means of Movable Property Act, number 57 of 1993, provides that the tacit hypothek of the lessor does not extend over movables which are the objects of notarial bonds or which are the objects of installment sale transactions. Ensure that you fully understand the operation of the tacit hypothek of the credit grantor. Section 84 of the Insolvency Act, number 24 of 1936 is important here. Also note that a conflict could possibly arise between the tacit hypothek of the lessor and that of the credit grantor. The section on liens is very important and must be thoroughly studied. You should be able to distinguish between the different liens as well as the types of expenses or improvements that can be made to things. Tacit mortgages are classified as, firstly, tacit hypotheks, that is, landlord and credit grantor. Number 2, rights of retention or liens, that is, enrichment and debtor creditor. Number 3, tacit mortgages in terms of statutory restraints against alienation of immovables. And lastly, judicial mortgages. And then you can just study diagram 24 on your own time. And then number 2, tacit hypotheks. Number 2.1, the lessor. Example number 1, X and Y lease a house on their farm to Z. Z lives in the house with his family and parents-in-law. Z fails to pay rent. And then example number 2, based on the facts in Bloemfontein Municipality versus Jackson's Limited, 1929. Z, S's farm manager, buys furniture on credit from a furniture store. X tells the manager of the store that he lives on S's farm, Highlands. S terminates Z's contract and Z moves to a municipal flat in town. He fails to inform the furniture store that he has moved to rented premises. Z fails to pay rent and the municipality applies to the court for an order allowing attachment of all the movable property on the leased premises. Okay, and then example number 3. X and Y lease a part of their farm, Waterford, to Z. Although Z has a successful cattle farm, he decides to begin large-scale farming with maize and other grain crops. Z is very busy and employs a foreman to take over the farming on Waterford on his behalf. The foreman lives with his wife and children in a house on the farm. Z has purchased a tractor on credit from C. The cooperative, which he stores together with his other farm implements in the shed on Waterford. Z registers a notarial bond over his green trader, his Yamaha generator, and his John Deere harvester in favor of the bank where he has overdraft facilities. To secure a rear rent, a landlord has a tacit hypothek over all the movables, the infecta et illata, which are brought onto the premises by the tenant. Anything belonging to third parties which is brought onto the rented premises by the tenant is also subject to the landlord's tacit hypothek, if the third parties know where the property is and intend the tenant to have the use of it on the rented premises for an indefinite period. It is then considered that the third parties have tacitly agreed to their properties being subject to the landlord's tacit hypothek. If the third parties wish to avoid this, they must notify the landlord that the tenant has their property on the premises and that they do not wish this property to be subject to the landlord's tacit hypothek. In the Bloemfontein case, the court stated the conditions under which movables belonging to third persons are subject to the landlord's lessor's tacit hypothek as follows. When goods belonging to a third person are brought onto the leased premises with the knowledge and consent, express or implied, of the owner of the goods, and with the intention that they shall remain there indefinitely for the use of the tenant, and the owner being in a position to give notice of his ownership to the landlord fails to do so, and the landlord is unaware that the goods do not belong to the tenant, the owner will thereby be taken to have consented to the goods being subject to the landlord's tacit hypothec and liable to attachment. Even where the property bears a third party's special mark, this is insufficient to release such property from the landlord's tacit hypothec. The landlord's tacit hypothec comes into operation as soon as the rent is owing. But the tacit hypothec does not in itself confer on the landlord a limited real right over the things subject to it. In order to render his or her tacit hypothec effective, it is necessary for the landlord to have the movables or infecta et lata that have been brought onto the leased premises attached while they are still on the rented premises or while they are in the process of being removed from the rented premises, but have not yet reached their new destination. This is known as the doctrine of quick pursuit. This tacit hypothec is protected in terms of Section 85 of the Insolvency Act No. 24 of 1936. In terms of Section 2 of the Security by Means of Movable Property Act No. 57 of 1993, movable property subject to a special notarial bond, that is Section 2, subsection 1a, or an installment sale agreement as per Section 2, subsection 1b, are not subject to a landlord's tacit hypothec. And then you can just study that activity on your own time. And then number 2.2, credit grantor, or seller on credit. For example, X and Y purchase their farm implements from C, the cooperative, in terms of a credit transaction. The cooperative is not prepared to grant credit to X and Y unless they provide security for the repayment of the installments. In terms of a credit agreement which reserves ownership, the seller retains ownership of the property until the last installment has been paid. Although we are dealing here with retention of ownership, it is a form of security for the credit grantor that the credit grantee will discharge the debt. While retention of ownership is not a limited real right of security to protect the interest of the credit grantee and his or her creditors, the ownership of the credit grantor changes to a limited real right in the event of the credit grantee's insolvency. Section 84 of the Insolvency Act No. 24 of 1936 confers a tacit hypothec on the credit grantor over goods delivered to a credit receiver. That is a hire purchaser in the event of the latter's insolvency. The effect of this section is that the credit grantor loses his or her ownership on insolvency and acquires a tacit hypothec against the insolvent estate. The credit grantor therefore becomes a secured preferent creditor of the insolvent estate. And then there's just another activity. And then we move on to number 3, liens, rights of retention. And then example 1, based on the facts in Buzzard Electrical Proprietary Limited versus 158 Jan Smuts Avenue Investment Proprietary Limited, 1996. J.S., the respondent, is the owner of a stand in Johannesburg. The respondent concluded a contract with a developer, D, to the effect that D would develop the property. Thereupon, D concluded a contract with B, the appellant, to the effect that the appellant would undertake the electrical work on the property. The appellant completed the work, but in the meantime, D was liquidated and the appellant could not recover its fees as provided for in the contract with D. The appellant continued to occupy the property and claimed to exercise a lien as against the respondent or the owner for essential, necessary, and useful improvements. The parties agreed that the appellant would vacate the property on the understanding that, should the appellant prove its enrichment claim, the respondent would pay compensation. The appellant instituted its claim for compensation based on unjustified enrichment. And then, example number 2, Y takes a tractor which he purchased on credit from C, the cooperative, to a garage for repairs. Y instructs the garage to replace the steering mechanism because it is defective. He also requests requests the garage to install a canopy over the driver's seat to keep out the sun and to paint the tractor pale pink because he is bored with the green color. Y stops paying installments to C and he refuses to pay the garage for the repairs. And then example number 3, based on the facts in Singh versus Santam Insurance Limited, 1997. While driving S's car, M is involved in an accident. M is insured with Santam, which must indemnify the loss. Santam instructs a panel beater to effect the repairs and pays him. After the repairs have been completed and paid for by Santam, Santam realizes that the premiums had never been paid by M. Santam cancels the insurance contract and collects the car from the panel beater. S now claims the car from Santam, which refuses to give the car to S. A lien can, in general, be defined as a limited real right to secure the claim of a person who has spent money or done work on another person's thing. It entitles the lien holder to keep the thing until he or she has been paid. A lien is generally regarded as a limited real right. There are, however, two different categories of liens, namely debtor and creditor liens and enrichment liens. This distinction comes from the different sources from which the debt that a lien secures can arise. In the case of a debtor and creditor lien, the principal debt arises from an agreement. A debtor and creditor lien is enforceable only against the other contracting party and is regarded as a personal right. When the principal debt arises from an enrichment, the lien is classified as an enrichment lien. An enrichment lien is enforceable against third parties and is regarded as a limited real right. Even though this classification of liens has been criticized, it is generally accepted classification. It is the generally accepted classification of liens. And then you can just study diagram 25 on this division. Liens always depend on the physical control of a thing. In other words, the holder loses his or her lien as soon as he or she loses physical control over the thing. If the lien holder was in control and was deprived of his or her control unlawfully or against his or her will, then upon application to the court, control will be restored to him or her. After such restoration, the lien will revive. Liens may apply to both movable and immovable things. A lien serves as security for the lien holder's outstanding claim for expenses incurred by him or her. The expenses which one may incur in respect of another person's thing are divided into 3 groups. Number 1, essential, necessary expenses, which are expenses essential for the preservation of the thing. Number 2, useful expenses, which are expenses that, while not essential for the preservation of the thing, nevertheless raise its market value. And number 3, luxurious expenses, which are expenses that are neither essential for the preservation of the thing, nor increase its market value, but merely gratify the caprice or fancy of a particular individual. On the basis of the principle that no one may be unjustly enriched at another person's expense, someone who incurs essential or useful expenses in respect of another person's property has a right against the owner of the thing to compensation for the expenses. Since he or she can be regarded as an unauthorized manager of another person's affairs, this applies even where he or she did not obtain the owner's consent before incurring the expenses. In order to secure his or her claim, he or she is entitled to retain the thing until he or she has been compensated for his or her expenses. As already mentioned, a lien that secures the principal debt which arises from enrichment is an enrichment lien. Enrichment liens can be divided into the following 2 categories. Firstly, if the expenses were essential or necessary expenses, his or her lien is termed a salvage lien, in which case the lien holder may retain the thing until he or she has been compensated for the amount by which the owner was enriched, or he or she was impoverished, whichever is the lesser. And secondly, If the expenses were useful expenses, the lien is termed an improvement lien, and the lien holder is entitled to retain the thing until he or she has been compensated for the amount by which the market value of the thing has been increased. The doctrine of unjustified enrichment applies to essential, necessary, and useful expenses only, and not to luxurious expenses. Someone seeking compensation for luxurious expenses which have been incurred in respect of another person's thing will be able to reclaim these only if the expenses were incurred under a contract, and then only from the person with whom the contract was concluded, and not from the owner, unless the contract was concluded with him. Only a debtor and creditor lien can secure a claim for luxurious expenses. Salvage and improvement liens, that is, enrichment liens, are limited real rights because they can be maintained against the owner and all third parties, including buyers, regardless of whether they were aware of the existence of the lien or not. Enrichment liens are limited real rights which come into existence by operation of law. Debtor and creditor liens are not limited real rights. These rights may be enforced only against the debtor and his or her successors who have knowledge of the existence of the lien. The basis for liability in enrichment liens is the enrichment of the owner at the expense of the lien holder. Where no enrichment occurred, the lien holder has no enrichment claim and consequently no lien. The main effect of the Buzzard decision is to emphasize two important requirements for the availability of an enrichment lien. Firstly, an enrichment lien is accessory to the principal debt, which is a claim for compensation based on unjustified enrichment, and therefore there can be no lien unless there is proof of unjustified enrichment. And secondly, the unjustified enrichment of the owner of a thing must be at the expense of the person who claims to exercise a lien over the thing. The first of these two requirements seems fairly obvious, but is often forgotten. The court stated that a lien does not exist in a vacuum. It is a real security right which ensures payment of an underlying claim for compensation based on enrichment. Without proof of unjustified enrichment, there is no principal debt and therefore no lien. The second requirement is slightly more complicated. It concerns the troublesome three-party situations where the owner of property X concludes a contract with Y to improve X's thing, and Y then subcontracts Z to do the work. After completion of the work, Z finds that Y has disappeared without paying the contract price. The question is then whether Z acquires an enrichment claim for compensation and a lien against the owner, that is X. The decision in Brooklyn House Furnishers Proprietary Limited versus Knutzer and Sons, 1970, which did provide Z with an enrichment lien against X in this situation, was criticized by various authors. The Buzzard Electrical decision overturned the Brooklyn House decision on this point and returned to the position assumed in Gous versus Yester Pools Proprietary Limited, 1968, and Weinland Construction Proprietary Limited versus Ashley Smith, 1985. The argument on which the Buzzer case rests is that neither a direct nor an indirect enrichment liability could arise in this situation, since any enrichment of the owner which resulted from Z's work was not without legal cause. It was no more than the owner contracted for with Y, and therefore such enrichment could not have been at the expense of Z, even if there was enrichment. The fact that Z was unable to enforce its contractual rights against Y was an unhappy coincidence, which should not be laid at the door of the next owner, X. It is important to distinguish between the two cases of three-party relationships referred to by the court. Number one, the first case is where person X contracts with Y to improve the thing of third person Z, and then Y wants to enforce an enrichment claim against the owner, Z. And number two, the second case is where the owner X personally contracts with Y to improve X's thing. Y then subcontracts Z to do the work. After completion of the work, Z finds that Y has disappeared. Z then attempts to enforce an enrichment claim against the owner, X. The Buzzard decision concerns only the second case. The Singh case followed the Buzzard case. A number of points regarding the existence of a lien based on unjustified enrichment were emphasized by the court. Number 1. Any lien the panel beater might have had against Singh or M terminated when Santam paid for the repairs, because the lien depends on the existence of a principal debt. Number 2. It was impossible for Santam to claim that the panel beater possessed or controlled the car on behalf of Santam without proof of attornment, since the car was actually delivered to the panel beater by M. Number 3. For Santam to prove a lien, it first had to prove enrichment, since a lien depends on the existence of a principal debt, and even if Santam was impoverished and Singh, the owner, enriched as a result of the repairs, such enrichment was not unjustified because it was the result of Santam's legal duty to indemnify M in terms of the insurance contract. Number 4. To rely on a lien, Santam also had to prove that the enrichment somehow occurred while Santam was in control of the car. While in fact Santam was never in control while the repairs were being effected, and by the time Santam obtained control, there was no principal debt or further enrichment. And lastly, to prove a lien, Santam also had to prove that it obtained control lawfully, but this was doubtful since it had no legal cause to obtain control from the panel beater to whom M had returned the car because the repairs were inadequate. The court therefore decided that Santam could prove no enrichment and therefore it had no lien. Singh succeeded in claiming her car back with her Ray Vindicatio. And then there's just another activity. And then we move on to number 4. A judicial pledge. A judicial pledge arises officially, that is, by the enactment by the sheriff in terms of a court order of the judgment debtor's movable or immovable things in execution of a judgment. The attachment of movables by the sheriff has the same effect as a pledge, and the attachment of immovables by the sheriff has the same effect as a special mortgage on immovables. When the attached property is sold in execution, the judgment creditor has a preference in respect of the proceeds of the sale. His or her preference is diminished, however, if other judgment creditors also obtain judgment against the judgment debtor before the judgment debt is paid. His or her preference must give way to an earlier preferent claim, for example, where the attached property was already subject to a bond when the attachment occurred. Where the attached movable has been delivered by the judgment debtor to a pledgee, the pledgee's right ranks in preference above the judgment creditor's judicial pledge. Furthermore, the preference which the judgment creditor's judicial pledge confers is extinguished by the insolvency of the judgment debtor, that is, where the judgment debtor becomes insolvent after the judgment creditor has had a movable or immovable thing attached by the sheriff. The sheriff then enjoys preference in respect of the costs of the attachment. It is possible, however, for the court to order that the judgment be executed in spite of the judgment debtor's insolvency, where the judgment creditor has a preferent claim. Where immovable property is mortgaged after its attachment, the bond is invalid. Thus we see that as soon as a judgment debtor becomes insolvent, the execution of the judgment against him or her is suspended when the sheriff becomes aware of the insolvency. Ownership of the attached thing or the proceeds thereof, which are in the hands of the sheriff pending payment, is henceforth under the control of the master, or the trustee of the insolvent estate after his or her appointment. This means that a judgment creditor who has had assets of the judgment debtor attached acquires no preferent right on the insolvency of the judgment debtor. But the pledgee who is in possession of the pledged thing does acquire a preferent right on insolvency of the pledger, as we saw when we discussed pledge.